Hello, I'm Rodger Citron. I'm a professor at Touro Law Center, and this is a Touro Law Review podcast. Our guest tonight, quite familiar with the Touro Law Review. It's Nick Maggio. He is a former editor-in-chief of the Touro Law Review. And Nick, thank you for joining us. And we're going to talk about what's known as the independent state legislature theory, which was the subject of a relatively recent Supreme Court case. And as we'll discuss, still has some relevance since we're in an election year, 2024. Before we get into the substance, though, Nick, please tell us a little bit about yourself.
Sure, Dean, I'm happy to be here. Thank you for the introduction. As you mentioned, yes, I was the former editor-in-chief of the Touro Law Review. Prior to becoming the editor-in-chief, I published one note with the Law Review. Since graduating from Touro, I've taken on a job as a prosecutor here in New York, but I've still kept my academic interest in following the happenings and the goings-on of the Supreme Court, particularly with the term where they heard the case of Moore versus Harper, which drummed up quite a lot of interest around the independent state legislature theory. And as you alluded to, I published a note recently in the Law Review covering that case, forecasting how I thought the court would have ruled, what I believe they should have done, given the prevailing case law and historical precedent, and with a bit of a synopsis at the end, reviewing the court's ultimate decision in that case. And so, like you said, we're coming into an election year here in 2024, where I think this case is going to have some serious teeth to it and some serious import. And so I'm looking forward to discussing that with you tonight.
Thank you. Can I just ask one more question about your own experience? Because you've been an assistant district attorney, but you'll be changing jobs soon. I don't know if you want to talk about that a little bit, but I'm curious, what's next?
Sure, absolutely. Yeah. So I recently accepted a position as a law clerk, a term clerk, with a new federal magistrate in the Southern District of New York, Judge Victoria Resnick. I'll be up in White Plains. I'm really excited for that opportunity to get to see a whole new side of our legal system, both the federal end versus the state side that I'm doing, and the civil stuff that I'll be exposed to there. So great opportunity for me. I'm really excited about it, and very thankful for the opportunity to do that.
That it will be interesting to be, in the middle with the umpire. At least that's how some people see the judge. So
that's right.
Yeah. And we can now turn to the independent state legislature theory, or ISL theory. I'm sure we're going to use that acronym at some point during the night.
Sure.
The thing I was curious about, I paid a little bit of attention to Moore versus Harper, as it made its way to the Supreme Court and afterwards. But I really want to start with, why did you start paying attention to it? Why did you first encounter the ISL theory, and why did you write about it?
Sure. So I first came into contact with the ISL theory, I think, when the majority of the public did, as the court was gearing up for these oral arguments in Moore versus Harper. And so just the idea of it kind of piqued my interest. And kind of, I guess, concurrently with that, I was doing a bit of reading personally on various facets of the law and the rise of certain legal movements, as well as consuming different documentaries and stuff like that, some of which I actually cite to in my note. And so taking in those recreational readings and documentaries and things like that, at the same time as hearing about this case, was just kind of a perfect storm in terms of my personal interest coinciding with my professional interest. And given my background, as we spoke about before, being on the Law Review before, I enjoyed writing, I enjoyed researching. And so the idea that I had the chance to lend, my pen to what I thought was a very important topic, something that I was interested in, just kind of swept me up. And so that's when I first came into contact with it. And that's why I continued with it. And I had an idea that I was onto something here, because I went to the Touro Law Review Supreme Court review, where Dean got to speak, and he gave his sort of a preview of what he was looking for in the coming term. So this was before the court decided more. And he was talking about these different cases that the court had on its docket. And he took a beat when he got to Moore versus Harper, and he said something to the effect of, this is the case that I'm really worried about. And so I said to myself, well, if I'm in company with Dean Chemerinsky, I must be doing something right here. I must be doing okay. And so that just kind of affirmed that I should continue with this. So that's how that came about.
Yeah, and I think for those of us who are new to the concept, we have to start at the beginning, which is what how would you define the independent state legislature theory?
Sure. So the independent state legislature theory, I guess in the wake of Moore, is actually not so much a theory as it is maybe a doctrine now, is the first thing I would say. And where it comes from are two separate clauses of the U.S. Constitution. The Elections Clause, which says that the state legislature can define the time, manner, and place for the administration of federal elections, as well as the Electors Clause, which in sum and substance says that state legislatures can prescribe the manner by which presidential electors are chosen for purposes of the Electoral College. And so the way that the doctrine or theory is derived from those two clauses is by some attorneys making the leap that because those clauses say legislature, the state legislature, that only the state legislature can promulgate rules and laws and whatever of the manner of administering federal elections without being bound by the ordinary checks and balances of, let's say, a state court or a governor or a state election administration official. And so that is, I think, the cleanest articulation I could give of what the actual theory or doctrine is.
I'm riffing here, so that's always perilous. But it's as if the two clauses that you read included the word exclusively next to state legislature. Would that be an accurate or fair paraphrase of what you're now calling? I think you're right. It is a doctrine as opposed to a concept.
I think so. It's exclusive. It would be exclusively the state legislature in the administration of federal elections. Now, I should mention that the second clause of the Elections Clause does carve out a role for Congress to play a role in checking any of the time, manner, or places that the legislature might prescribe. But at least in the context of state actors being checks on each other, whether it's a state's highest court or a state election administration official, they couldn't check the state legislature under that doctrine.
Right, right. The governor, the state courts, no role.
Correct.
And it may be, I was thinking about this after reading what you wrote and so on. I think that it may be that the safest place, if you will, or the clearest place to start might be with the Supreme Court decision itself in Moore versus Harper. And so I should just ask you, what's the case about, or what, describe the case. But to be clear, because it came up from the North Carolina courts, right? It is not a case that was litigated in the federal system and ended up in the Supreme Court in that fashion. It is a case, when it came to the Supreme Court, it came from the North Carolina courts. With that, go.
That's correct. That's correct. So it came from the North Carolina courts, and and I think you and I were corresponding before doing this show, there was a standing procedural aspect to this case, which maybe we could get into, or maybe we could just head off. But at the heart of it, this case came to the Supreme Court from the North Carolina Supreme Court after one iteration of that bench on the North Carolina Supreme Court made a ruling about North Carolina state's congressional maps. The state legislature in North Carolina drew a set of electoral district maps. Those maps were challenged as being an impermissible an unconstitutional gerrymander under the state's constitution. North Carolina is fairly unique in that it has a free and fair elections clause within its state's constitution. So the petitioners challenge those congressional maps under that provision of the state constitution. And after a series of legal battles, the North Carolina court said, you're right, this is an impermissible, unconstitutional gerrymander under our state constitution. At that point, the respondents in that action said, well, hold on, this violates the independent state legislature theory. And the Supreme Court, after a series of other legal battles, agreed to hear that case on those grounds about whether or not effectively the state court could say that an action of the state legislature drawing congressional maps was impermissible under the state constitution and could effectively check them. So that's how the case ended up getting to the Supreme Court. I could go into what the court said, or
Yeah, and this is properly, well, I do want to set aside the standing. That is only because as someone who teaches administrative law, I'm increasingly baffled by the court's standing jurisprudence, and we could be here all night, and I think I would still be baffled by the end of it. So, with respect to the merits, we're sorry, right? We're not recording this, right? No, but the reason why a decision with respect to, by the North Carolina Supreme Court, or the North Carolina courts are litigating, or what is being litigated before them is a provision of North Carolina's constitution. But the reason why the case is properly in the Supreme Court is because the contention by the respondents was that is the fact that the courts are involved, that violates the U.S. Constitution, and
Correct.
That makes the case properly heard or reviewable in the Supreme Court.
Correct.
Yeah, and this case was not decided unanimously.
That's right.
So, could you, break down, or the count, and who wrote what and who said what and who voted how?
Sure. So you had Chief Justice John Roberts writing for the majority. It was a 6-3 split. And then you had Kavanaugh agreeing with the majority, however, writing his own separate concurrence. And then you had Thomas, Alito, and Gorsuch dissenting. As for the majority, so the majority ends up holding in the case that, no, the U.S. Constitution does not vest exclusive and complete authority with the state legislature to administer federal elections. That is to say that they are bound to ordinary checks of state judicial review. And the majority teases through both the history around state legislatures and their practices with administering federal elections, as well as their relevant case law to come out to that conclusion that we've often found that state legislatures are bound to certain checks and balances by concurrent state authorities, whether they be governor's vetoes or popular referendums by people, or ultimately state courts. You have Justice Kavanaugh concurring with that result, and not really taking issue with any of the reasoning that the majority provides. However, what I gather from reading Justice Kavanaugh's concurrence is that he wanted to emphasize that this standard that the court has laid out has some teeth to it, has some substance. Because when you read the majority's opinion, what you find is that they provide a bit of a vague standard for state courts and federal courts to use, because what they say is, yes, the state legislature does not have complete and exclusive authority to administer these, but state courts don't have free reign either. State courts cannot act, what the court says, outside the bounds of ordinary judicial review in making these decisions about what is state law and what is state constitutional law. And so what Justice Kavanaugh says is he tries to provide some guide rails as to what courts should be looking for when interpreting this decision, what might be more of a novel case that the court should be weary of, as it might run afoul of that sort of acting outside the ordinary bounds, or what might not constitute that. The dissent written by Justice Thomas takes aim at the majority in two ways. One, it takes aim at the majority's even hearing the case on the standing issue that we discussed before. But on the merits of it, Justice Thomas takes particular aim at the court in just reading the prevailing case law differently. What Justice Thomas says is he tries to draw this distinction between a procedural constraint on a state legislature versus a substantive constraint on a state legislature. And what Justice Thomas says is that our case law, our precedent, has always defined what a legislature is and how it goes about exercising its powers. And that's fine. But we've never said anything about placing substantive constraints on a state legislature. And so because of that, Justice Thomas turns to the United States Constitution, reads it quite literally or textually to say that no, the state legislature is the last and final word on the administration of federal elections. Full stop. And so that's where the majority and the dissent divide, I should say.
Yeah, and I thought, what do you think? Well, Justice Thomas in his dissent, as you described, is engaged with respect to the merits in a, he would say, or principally or primarily a textualist approach. How would you characterize Chief Justice Roberts' opinion? What impressed me in it was there's a really nice elucidation of separation of powers, which is not, necessarily textualist. That is, one could say, we don't see the phrase separation of powers, in the Constitution. Nonetheless, because there's three branches of government and so on, there's a way of saying that, well, that's the structure. And so that's at least implicit or even not so implicit, the premise of how the government works. That is to say that because there's three branches, well, then separation of powers is sort of a core principle and a core operating principle, if I can say that, have that mean two different things. How did you read the majority?
The majority interested me mainly in the people that comprised it. One of the main reasons, at least, is because with Chief Justice John Roberts, one of the cases that he cites to repeatedly is Arizona State Legislature, which was notorious for defining what a legislature is and giving a fairly expansive definition of what a legislator is. That is the power to make laws. And I believe it was the late Justice Ginsburg who actually penned the majority opinion in that case, with Chief Justice Roberts dissenting. So it's interesting to me to now see the Chief Justice that was dissenting in that opinion to define what the legislature is, relying on that majority decision to say, no, hold on, wait a minute here. And the one thing I should say in terms of characterizing the majority opinion is that I think the Chief Justice had the foresight to understand what embracing a maximalist version of this doctrine would invite. And if I could, one of the third parts of the dissent, of Justice Thomas's dissent, talks about how this could open a bit of a Pandora's box in terms of litigants bringing actions in highly political charged cases to these various courts, and federal courts kind of making snap emergency decisions with cases coming to them in emergency posture, and it could be a real problem. And I think Chief Justice Roberts acknowledged that, but then acknowledged what would happen if he endorsed a more maximal or a more serious version of the doctrine and said, yes, we may be opening a bit of a Pandora's box here, but to do the opposite would be opening a bit of a Pandora's chest. Because to say that state legislatures are completely without check and balance from state courts would open up even more untold litigation issues in serious federal elections.
Yeah, yeah. I wonder, um, you were, I believe, critical of the theory in your paper. And let's talk about that, and then I'll go to the question I have in my mind, but really sequentially should come next. Did the 6-3 vote surprise you? Was there any aspect either of the reasoning or the vote count that, because you were pretty immersed in this to write the bulk of the paper, that was a left turn instead of instead of the path that you thought the court was headed towards, or the direction it was headed towards, in deciding the case?
Yes and no. So in terms of the path the court took to get where it landed, I wasn't surprised by that because I thought that the case law was fairly clear in terms of Smiley and Arizona State. And so I thought that a court engaging in its own precedent would be left with no choice but to reach this conclusion that it did, to some extent, because I definitely didn't foresee the court saying, okay, state legislators are bound to the checks, but state courts don't have free reign. That was a bit of a twist. I was surprised by the composition of the vote, mainly because of what we spoke about earlier, which is that you had Chief Justice Roberts dissenting in Arizona State. So you already had him on paper sort of welcome and open to the idea of a very narrow reading of what a legislature is and the powers that are and who's allowed to check state legislatures. The wild card vote for me was Justice Barrett. She hadn't written much on this issue and hasn't really engaged in any of the same sort of litigation or argument around it that some of the other justices have. And so I didn't know where she would land on it. Her questioning that I kind of teased through on my notes suggested that she wouldn't be open to adopting a more maximum version of the doctrine. And I guess that's kind of why she landed the way she did, because of this more tempered down version of it. But the composition of the vote did catch me by surprise.
Yeah, and I feel like perhaps this is a bit late in the discussion. This is the 2023 decision.
Right.
I believe this was last summer that the
Correct.
case was decided. We're here in 2024, which means, of course, among other things, Justice Barrett was on the court. And so here's the question that I wanted to ask 4 minutes ago, which was, there was a way out, right? The standing point.
Yeah.
And do you think the court should have taken it? That is, Chief Justice Roberts, I'm older than you, as I think our viewers will be able to discern, famously said, at his confirmation hearings, there's the umpire quote, that's what he's sort of most famous for, but there was an idea of that I think to characterize it, the idea of articulating an ambition for the court that a more modest role for the court in our life, resolve more disputes politically, less legally. And I wonder here, because as you've said, Roberts' majority opinion, it decides the case.
Right.
Not much guidance, And there is kind of this, really, to use the phrase that you used, that is the maximal version of each theory. It is the Pandora's box. That is, well, do we trust the judges over, who now have judicial review, some degree of judicial review? There's the dissent says, do you really want them deciding the election? And of course, the majority's counter is, yeah, but if there's no judicial review, then you've turned the idea of rogue legislators is the possibility. And since we don't have much guidance coming out of the decision, what did the decision accomplish? And that which comes back to, should they have dismissed on standing? That
And you hit the nail on the head about what did the decision accomplish, and Justice Thomas points directly to this in his dissent, because I know we said we maybe don't want to get too much into the standing, but just to give a bit
go
of
ahead, actually, because now I think that we've done the merits. I think we can do standing. I just didn't want to get it tied up with in the discussion. But go ahead.
fair enough. So the North Carolina court reconstituted itself because the judges there are elected. It reconstituted itself during the pendency of this action, and just in terms of party registration, it flipped from a majority Democratic bench to a majority Republican bench. And after that flip, but while the case was pending at the Supreme Court, the North Carolina State Court agreed to reopen and rehear arguments on the case, and came down with a new decision on the merits of the North Carolina case. And it said effectively, okay, North Carolina, we will allow you to use these 2021 maps that you drew up, and put them into effect. And that was the decision. So the court actually asked for emergency briefing on this issue as to whether or not the court still, in fact, had standing, because there was no relief that the court could deliver to the state that it did not already have. And it was it was interesting because the Solicitor General in the case was arguing at the court, no, this case is moot, do not decide it. And in some respect, they ended up winning the case, even though the court did find it was moot. And the attorneys for the petitioners in the case were like, no, this case is alive and well, please decide it. And the court did, but not in their favor. So there was a fun bit of irony in that. But Justice Thomas, made it very clear that deciding this case doesn't give the parties any relief that they don't already have. Their grievance has been redressed already. And what the majority says in response to that, or to justify hearing the merits of the case, is, well, technically the order of the North Carolina Supreme Court doesn't allow them to use the specific 2021 map. It only allows them to use them as a guidepost and to put a redrawing of those same maps into effect. But because they can't use those 2021 maps, there's still a live controversy here, which I found a bit tortured. If I could be so, if I could take that indulgence as a justification.
The views here tonight are your own. They do not represent any past, current, or future employer. That way you're insulated.
I appreciate that.
Yeah, hearing you walk through it again reminds me of my own. I'll say it this way, which is my civil procedure professor used to say in moments like this, I'm puzzled. And
right.
So I remember having that feeling of I'm puzzled reading this part of the discussion of the majority's opinion. Do you think I have a couple other questions, but I want to make sure that, but they kind of zoom out, if you will, and I want to make sure that we've adequately covered Moore versus Harper. Is there anything more that within, about the case itself that's worth noting?
I don't think so. I mean, covering the standing issue, covering the merits of it, noting the different constituencies in each respective camp in terms of the majority and the dissent, and Kavanaugh's concurrence. I mean, the only thing worth noting is that concurrences are not binding law by any means, but it's important to note that this doctrine, in some measure, was born out of a concurrence in Bush versus Gore. And so I think people ought to pay particular attention to the concurrence in this, not just because substantively of what it says, in that I think courts will be looking to that concurrence as sort of the guide rails on how they ought to decide these cases, but because if history is precursor, then we'll see something come out of the concurrence in this case as well.
Yes, and that's also, I'll circle back to the Bush v. Gore point, before we wrap up. But two questions. what do you think this case tells you or illustrates about the current Supreme Court? It did have, we talk often about, oh, it's a 6-3 court, and that as a shorthand refers to 6 justices appointed by Republican presidents, 3 justices appointed by Democratic presidents. But the 6-3 here, in that sense, crosses party lines with the 3 justices appointed by Democratic presidents being joined by 3 justices appointed by Republican presidents. Does that is that at all helpful in any way in understanding, you know, what this case could indicate about the current court?
Um, I guess what this case tells me about the current court is you just never know. You know, because if you read my note, you'll see that I was not hopeful, right? I wasn't hopeful about this decision. I thought it would come out the other way, with the court endorsing uh, the most maximal version of this doctrine. And so they didn't, but with a caveat that they did um, take they did take for federal courts a bit of power, and articulated a rule in such a way that now federal courts have a bit more oversight, at least explicitly, over state legislatures and the administration of federal elections than at least they clearly did before. And I alluded to this, I explicitly stated it in my note about what some observers of the Supreme Court have called the Roberts two-step, where Justice Roberts will pen an opinion of very temperamental, very moderate, very modest, and articulate a relatively um, a relatively safe and fine rule about whatever sort of case or controversy is before them, and then in a subsequent case will seize on that to do something rather extreme. And so the one example of this that springs to mind is Shelby County v. Holder, where Shelby County was the second case in a series of voting rights cases being heard before the court at the term. And as we're taught, Shelby County eviscerated preclearance of the Voting Rights Act. And the justification for that was predicated on a much more moderate rule that Roberts had penned in the preceding case. And so some of what this case tells me is that it's sort of business as usual for the Roberts Court in issuing these more incremental decisions in blockbuster cases, which tells me that let's see what comes in the upcoming terms, especially on the heels of a 2024 election.
Yeah, the step two, as it were. And this is well, do you have any sense? But I think you don't have a crystal ball, so I'm curious to see how you answer the question, right? Which is, any sense of how the doctrine could be in play in this year, which of course is a presidential election year, is a federal election year. Um, I'll leave the question at that. It's April. It may be too soon, but go ahead if you have thoughts.
Sure. Well, I have thoughts on that. I don't know. I know it will be in play, but I'm not sure how it will be in play. And if I could point to a few examples, so one of which at least I cover in my note, which is that in the wake of COVID, we had the 2020 election, and so there was a case in Pennsylvania whereby the Pennsylvania voters who were allowed to mail in ballots went to the state's highest court to say, hey, look, the mail system isn't working the right way right now, given everything that's going on, but we want to continue to vote. We want to take advantage of mail-in voting. Can we extend the deadline by 3 days to receive mail-in ballots? And the Pennsylvania Supreme Court said, sure, that's fine. And the United States Supreme Court heard that case after some parties challenged that decision by the Pennsylvania Supreme Court. And the Supreme Court said, no, that's fine. But some justices did take umbrage at that decision. For instance, Gorsuch penned an opinion saying that this was not okay under an independent state legislature like theory. And so there was a similar issue, although it didn't reach the Supreme Court, in Texas, where there was drive-through voting, where there, voters were allowed to drive through to vote, and that was challenged. The state legislature turned around and said, no, 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 this is fine. And then the case was dismissed as moot. But what we have here are instances of state courts going beyond what a particular statute might say is permissible in the administration of federal elections. And it's been well documented now that there have been at least several instances of folks putting together slates of electors for the president that different law enforcement bodies have looked into. Slates that weren't ultimately what the state decided it was going to send, and with the intention of those being certified as the state's electors, as opposed to what the state was actually going to send as the state electors. So what we have here are three instances on the heels of the 2020 election that courts and law enforcement bodies had to get involved in. And so all that is to say, I don't think anybody foresaw any of that happening at any point, but I'm cautious and mindful that this doctrine might influence, had it been in play then, might have changed how some of the courts ruled the way that they did. And I'm trying to be a bit careful here in how I say that, because I don't know exactly what would come up, and I don't know how this theory would play in. But I don't know that Pennsylvania would come down the way it did, or that a Supreme Court would come down the way it did in that case, if the independent state legislature doctrine were in play like it is now, for instance.
Yeah, because, right, is this a fair sort of shorthand, right? That is, if the maximalist version of the doctrine prevails or did prevail, then the court, right, lacks jurisdiction. The state court lacks jurisdiction to interpret, enlarge, really, I'll stick with interpret the statute, because not only is it, that is, it's not a question of what does the statute mean, it's a question of the arbiter. And the maximalist version says you don't have a say, to the courts, right, to the judiciary in the state. You don't have a say in this. Yeah. The I've been working with the current editorial board on the next issue that's going to be published, which is we had a conference on Justice Felix Frankfurter, and it was inspired by a superb biography by Brad Snyder, who's a professor at Georgetown. And we have a piece from Professor Snyder. I should say the Law Review has a piece forthcoming from Professor Snyder. And at the core of Frankfurter's jurisprudence was this question, legislatures or courts? And Frankfurter was very much, and this is a part of the Snyder thesis, if you will, of Frankfurter, was that his view is Frankfurter consistently, as a lawyer and then as a justice, was the legislatures, not courts. Don't put your faith in courts. And so he talks a little bit about Moore versus Harper in his piece in the Law Review. And he kind of sees it down the middle, if you will, as a decision. But what he loves, and I know this because I was just looking at the page proofs today, is the subsequent turn of events. That is, the judicial election in North Carolina, which at least resolved, if not mooted, the controversy. And he sort of has this turn of phrase about Frankfurter would have loved the fact that, in effect, well, the voters did decide ultimately, rather than the court having the final say. And it's really, we haven't talked about the Dobbs case, but this question, courts or legislatures, it's a fundamental question that I think we're all wrestling with, not just law students and law professors and lawyers. I mean, we all are, but I think as a nation. Um, and what's so interesting, of course, is that Moore versus Harper, as you discussed, um, absolutely is a case that weighs in, that takes a position in a particular context on courts versus legislatures. Um, so, um, are you doing anything now? I don't know if you have time to sort of follow up on, expand what you wrote about.
No, no, I'm not. Partly because I kind of want to see how it shakes out.
What
Um,
happened?
what I want to see what happens,
Yeah.
because I'm really curious. Like I said, I think in preparation for writing my piece, I was reading a few articles, one of which claimed that the 2020 election was subject to the most litigation of any election, you know, before. And so, with that being said, I want to see how the cookie crumbles, what the cards are in terms of courts, state courts operating within the ordinary bound of judicial review, and how various courts interpret that, and how various federal courts interpret their role now in overseeing and being the umpires for this ordinary bounds of judicial review for state courts. Um, Maybe after that happens, I'll reconsider dipping my toe in the water there. But for now, I'll let the courts be, and see how they see how they do.
Um, well, on that note, I think that's going to conclude our discussion. I greatly appreciate you taking the time to speak with me and to do this Touro Law Review podcast. And who knows, we may have you back on sometime after November.
Maybe I really appreciate you guys having me, and thank you so much.